This is Introduction to Law 1157, Week 8, Summer Semester 2013-2014. This week we return from the break, and in the remaining weeks it's my intention to be quite practical in terms of the discussion topics and the advice that is given. I'd also encourage you to make this interactive, so please interrupt me at any stage as we progress with any questions. Tonight I'd like to start with a discussion about criminal law. We've certainly talked about criminal law procedures to some degree, and the role of barristers and briefing barristers and court etiquette. I'd like to start with discussion of the criminal code. The code is not a statute itself. It is in fact a schedule to the Criminal Code Act of 1899. But when we talk in terms of criminal law, the most important piece of legislation, or the most important document rather, to consider is the criminal code. And the idea of a code is it is intended to be a comprehensive statement of the law in a particular area, in this case in criminal law in Queensland. However, it is apparent that there are many other statutes that relate to criminal law that aren't contained in the criminal code. So the original intent, if you like, has been watered down by the fact that there is new legislation covering more specific areas of practice. For example, the Drugs Misuse Act is essentially a code in relation to drug laws in Queensland. The code is intended to be comprehensive, and I refer you to a case of Mellifont against the Attorney General, 1991, CLR 289. It's a High Court decision, and in that decision the High Court held that it is not legitimate to look to the common law to interpret the criminal code unless the code provisions are ambiguous. So in that sense, the High Court has reinforced what is intended behind using the word code, and we see code in other contexts as well, but for tonight we're talking about the criminal code. Even though the code itself is very old, it has been amended on many occasions, and when it was introduced it established essentially the modern criminal law in Queensland, and many of the old terms that are used in general parlance but not part of the law were overtaken. For example, the term larceny was removed, and in its place the crime of stealing. Assault and battery, which you may have heard of, became simply assault in its various forms. So some of the old terms were removed as a result of the criminal code, and to my knowledge they're not now included in the law at all, even though you might hear about these terms from time to time. I'm going to refer you in the code to some of the definitions initially, and in particular the definitions are in section 1. I'll highlight some of the more important ones. Adult, as far as the criminal code is concerned, means a person of or above the age of 18 years. Now the reason I highlight that, even though it might seem obvious, is that generally speaking our criminal law regards a person as an adult as a person who has attained the age of 17 years. So a 17-year-old who is charged with an offence under our criminal law is dealt with as an adult, notwithstanding that definition that I've referred you to in the criminal code. The consequence of that is that a 17-year-old it goes through the magistrate's court rather than the children's court initially, and is sentenced as an adult, which means that the sentencing regime is essentially contained in the Penalties and Sentences Act, which is the sentencing piece of legislation for adults, and not the Youth Justice Act, which is
John,
the sentencing regime for children. Yes, John?
When you say that the offender is 17 years or older, now is that at the time of the offence or the time when the case comes to court?
That's generally speaking at the time of the offence. There are some exceptions, but those exceptions basically relate to a person who is 18 or more even though they may have committed an offence as a juvenile. But almost always, when we're talking about a person who committed an offence as a 16 or 15-year-old, let's say a 16-year-old, they will be treated under the children's legislation, even though they have attained 17. Thank you, John. Any other questions from anyone from what I've said so far?
No.
All right. Still on the topic of definitions, bodily harm. You may have heard of the charge of assault occasioning bodily harm. Bodily harm means bodily injury which interferes with health or comfort. I'll refer you to a decision of Scratchard, S-C-A-T-C-H-A-R-D against the Crown, 1987, 27 Australian Criminal Law Reports at 136. So that's 1987, 27A, Criminal Law 136. In that case, the decision was that a sensation of pain alone without an identifiable bodily injury is not sufficient to constitute bodily harm. Now, the reason I mention that definition is this, that on its face, when one talks about an injury which causes interference with health or comfort, that's a very low threshold. And the importance of that decision I've referred you to is that there must be something more than simply pain alone, which you might think is all that's needed when one considers the section referred to. But there must be some identifiable bodily injury. And in criminal law, one of the things that defence lawyers do on a very regular basis is try to negotiate down the charges. So sometimes you can't negotiate a charge to go away, as it were, but you can negotiate for the charge to be downgraded. So, for example, if someone is originally charged with assault occasioning bodily harm, it may be possible through negotiation to suggest to prosecution to replace that charge with a charge of common assault, which is a far lesser charge, carrying with it significantly lesser penalties. In the definition section, I'll also refer you to circumstance of aggravation. We see this often in terms of some particular type of offences. For example, in relation to dangerous operation of motor vehicle, a circumstance of aggravation may be that the person was intoxicated at the time. So there is the principal charge, the main charge, if you like. Now, how do I describe a circumstance of aggravation? Is adding fries to the charge, if you know what I mean. It's adding an extra component which it makes it more serious. And in lawyer talk, as per the terms in the criminal code, we talk about a circumstance of aggravation. We contrast that term to the term simpliciter, which is often used, so that if, for example, your client says, I've been charged with bodily harm, or more particularly assault occasioning bodily harm, you might seek to ascertain from prosecution at an early stage whether that is assault occasioning bodily harm simpliciter or assault occasioning bodily harm with a circumstance of aggravation. An example of a circumstance of aggravation in that context would be that the offender committed the bodily harm offence using a weapon, or using threats, or in company with other people. So when we talk about in company, it means with one or more other persons. So they're examples of circumstances of aggravation. No questions there? All right. I'll move on. The next one I have is disclosure obligations. Just be aware that in criminal law, and this is a really basic concept, well, under our law, defence need not prove anything. Prosecution must establish everything. And part of the obligation upon prosecution is to provide appropriate disclosure to defence. So if in your first week in a law firm, you're confronted with a client who's charged with, let's say, assault occasioning bodily harm, you need to establish the nature of the charge. You do that by contacting prosecution and asking for a copy of the court brief, more commonly known as the QP9. And on that QP9, you seek to establish what is the charge. The client may say bodily harm, but it might actually be unlawful wounding, for example. You find out whether there are any circumstances of aggravation, and you ask the police to provide you with disclosure. At the initial stage, the standard request for disclosure is a copy of the court brief / QP9 and a copy of any alleged criminal history. But the disclosure obligation upon prosecution goes well beyond that, and if you wish, you may ask for a full brief of evidence, etc. Now, you wouldn't generally do that at the start. I would recommend that you simply ask for the court brief and the criminal history to start with. If, as a result of studying that in conjunction with your client, you make the decision that you want to contest the charge or go further, then through the court system you may ask for a full brief of evidence, which would need to be provided, generally speaking, 6 to 8 weeks after the date that it's requested in court. So any questions about that? All right. Grievous bodily harm is bodily harm but more serious, and it means loss of a distinct part or organ of the body, serious disfigurement, or, this is the third one, and this is the one which causes the most concern, any bodily injury of such a nature which, if left untreated, would endanger or likely to endanger life or cause permanent injury to health. So when you're acting on behalf of a client who's charged with grievous bodily harm, you need to consider those aspects of whether the injury is likely to endanger life or cause permanent injury to health. The next thing I want to discuss is indictment. It's defined under the Code as a written charge proffered against an accused person in order to have the trial proceed in a higher court. In the Magistrates' Court, you won't be speaking about indictments, so it's a very easy mistake to make. Indictments are only relevant in the higher courts, the District Court and the Supreme Court. In the Magistrates' Court, it may be a bench charge sheet, but it's not an indictment. So just bear that in mind. An indictment is simply just a piece of paper which is essentially handed up to the judge and identifies the nature of the charge, the person against whom the charge is proffered, and some other relevant information such as where the charge allegedly occurred. The final definition that I want to refer you to is premises, and it may interest you that premises includes a vehicle or a caravan or a tent or even a cave. So it is possible, for example, for someone who steals something from a tent in a caravan park to be charged with essentially burglary because they have broken into / entered a premises or even a dwelling in those circumstances. All right, I won't trouble you with any more definitions, but I commend you to read Section 1 of the Code, which provides an outline of some of the more important definitions in our criminal law. Please interrupt me if there's any questions, but otherwise I'll move on. The next thing is Section 3, Division of Offences. Essentially, there are two types of offences in Queensland. There are criminal offences and there are regulatory offences, the criminal offences being more serious, as the name might imply. And within the context of criminal offences, we have crimes, misdemeanours, and simple offences. Now, they're all criminal offences, but within that category, we have those three subcategories. Now, crimes and misdemeanours are regarded as what we call indictable offences. That is to say that unless there is some exemption, an indictment must be presented. And as we've discussed, an indictment is something which is presented to a district court or a Supreme Court judge. So where an offence can be dealt with or should be dealt with by way of indictment, that is called an indictable offence, as opposed to a regulatory or simple offence, which is something which is undertaken through the magistrate's court. Unless something, and what you'll see when you're reading the code is that various offences are categorised in accordance with the divisions in section 3. So if you find that in your reading that something is referred to as a misdemeanour, go back to section 3 to give you an overview of what misdemeanour means in the context of criminal law proceedings. Can I just make this observation? Since 2010 and the Moynihan reforms, many matters which were previously dealt with on indictment in the higher courts are now dealt with in the Magistrates' Court. They're still indictable offences, but the specific provision to the effect that they are indictable provisions that must be dealt with summarily. So we have this kind of hybrid situation, a merging of the concepts, which I presume back in 1899 were quite clear-cut. All right, so I'm hoping that when you find yourself in a situation where you're needing to give advice, or you're before a magistrate, or you're having to speak to, say, a partner in a law firm, you understand what we mean by these concepts of indictable as opposed to summary offences. Any questions about that?
Regarding the Moynihan report, John, I believe one of the consequences of that was that cases that would have been heard in a district court, and so the defendant would have possibly getting legal aid, they're now heard in the magistrate's court where legal aid is not appropriate. Is that correct?
Yes, very much so. Certainly as a result of the reforms, overwhelmingly, the result is that many matters which were dealt with in the district court are now dealt with in the magistrate's court. If someone was financially eligible for aid, they would gain that funding, that assistance through legal aid automatically in the district or Supreme Court. That's not the case in the magistrate's court. It may be the same charge which was dealt with in the higher court, but because it's dealt with in the magistrate's court, funding is much more difficult to obtain, and it's certainly not automatic. So thank you for that observation, John. That's correct.
No, I was just reading an article in the UK papers that legal aid person went on strike this morning because of reduction in funding. No cases were allowed to go ahead this morning, and they estimate that has actually cost the court system nearly $1 million.
Yes. I won't go into the politics of it, but yes, I understand. I can sympathise. All right. Thank you for those observations. I'm going to refer you to section 5 of the code, which deals with the question of arrest without warrant. And in that regard, the classification of offences in section 3 is relevant because it does provide a basis for determining when an accused person may be arrested without a warrant. Now, the basic rule is this: in the case of a crime, you'll recall when we talked about crimes as being one of the 3 types of criminal offences, except where otherwise stated, an offender may be arrested without warrant. Ordinarily, a warrant is required in the case of a misdemeanour, being a lesser offence or a lesser criminal offence. Having said that, in the same way that I've said the distinction between indictable offences and summary offences has been blurred over time through exceptions, the same rule applies, or the same principle applies, in relation to arrest without warrant, because many of the provisions in the code create exemptions to the general rule in the section. For example, instances of crime where an offender cannot be arrested without warrant is referred to. And likewise, in instances of misdemeanour, where previously they could not be arrested without warrant, they now can be. So there are many instances where, for example, going armed as to cause fear or indecent act of dangerous operation of motor vehicle, they're misdemeanours, but the code specifically provides that the general rule does not apply, and there is an exemption from that general rule, and even though they're misdemeanours, an accused person can be apprehended without warrant in those particular cases. I guess what I'm saying is that it's very hard to give blanket rules, but be aware of where to look, so that if you're in a position where you need to give advice fairly quickly, or you're arguing a case, you can find out whether a particular matter is part of the general rule or part of the exemption. So I'd refer you to section 5 in that regard, where it's set out. Now I'm going to, and I'm really just taking you through some snapshots of the criminal code. I'm going to refer you to chapter 5 of the code, which is headed Criminal Responsibility, and this chapter essentially sets out the defences to charges of criminal offences. The more important that I'm going to refer you to, section 22, ignorance of the law, bona fide claim of right. 23, intention, which is really accident. 24, mistake of fact, where there's a distinction between a mistake of fact and a mistake of law. Section 25, which is the defence of extraordinary emergency. 26, which is dealing with the presumption of sanity, and the related section 27, which deals with insanity itself. Section 28, which deals with intoxication, and 29, which deals with immature age. When you're studying criminal law as a subject, and when you're practicing criminal law, that group of sections in Chapter 5 is a very important section, and one that you need to certainly keep in mind and apply. I'll also mention, in terms of defences, that Section 268, which deals with provocation, and 271, which deals with self-defence, are also very important matters to keep in mind. So if you're going to try to just bring yourself up to speed on criminal law quickly, have a look at those sections and just try to get a feel for them. I won't go into any parts of those sections now, but just simply refer you to them. Any questions about those? All right, thank you.
Just one, sorry, John.
Yes, Rachel.
That's defences to criminal offences. Does that include the misdemeanours and the crimes as well? So it's all three?
It does, and it also applies, generally speaking, to summary offences and regulatory offences. So I'm glad you raised that, because it's a very important point that these offences or these defences, even though they're contained in the criminal code, can be used by defence lawyers in dealing with charges under different statutes, generally speaking.
Okay.
Can I give you this example? Under our traffic laws, you'd be aware, of course, that you can't drink and drive unless it's under the prescribed minimum. Back in the 80s, people would use, and in particular a very well-respected barrister by the name of Bob Brewer and his brother Frank, who I briefed on a number of occasions, would use Section 24, mistake of fact, as a defence to a drink driving charge, on the basis that even though the person who drove the vehicle intoxicated was over the limit, they honestly and reasonably believed that they were under the limit, and that then provided them with a defence to the charge. I give that example because it's essentially not available anymore. It comes back to the whole concept of how our laws operate, in that we have the code and the legislation which provides the law. That is then used by lawyers, and in court cases, the defence is the decision of the court is not popular, and Parliament then overturns that decision by saying something to the effect that, in relation to this particular charge, Section 24 of the Code is not available as a defence. So you can see how, and I remember talking about this in the early stages, how things become very circular in their application. But the point of that is that these defences are, generally speaking, available throughout all of our criminal law proceedings. Thank you, Rachel. Any other questions? All right, let me move on. Okay, you really do need to understand at a very early stage, if you're practicing in criminal law, which court will deal with various matters. And I know I've talked about this before, but I'd like you to have a look at Section 552B of the Criminal Code, which basically outlines where the defence has the election to deal with certain matters, either by indictment in the district court typically, or summarily in the magistrate's court. And it's important because it's your election as a defence lawyer, if you are a defence lawyer, that you're aware of those circumstances, because the magistrate will be inviting you to provide an election as to jurisdiction. And if you don't know what the magistrate means by what is as to the term election as to jurisdiction, then it can afford some embarrassment, of course. And then, of course, even if you know the term, you've got to understand what election you have available to you in those circumstances. I won't go into that anymore, other than to say that once again, as a result of the Moynihan reforms, well, because essentially the Moynihan reforms in this regard are contained in, for our purposes, Section 552BA, which categorises certain matters which previously were subject to an election as being matters which must be dealt with in the magistrate's court. It's quite convoluted. You may be able to find material online which will assist you substantially in that regard, or when you get into a law firm you might avail yourself of various cheat sheets which have been prepared by a number of prominent criminal law practitioners in Queensland particularly, which are available for use generally speaking. I hope I'm not doing a disservice to them by saying that people use those sheets, but they do. So be aware of that fact that you may be called upon to make an election as to jurisdiction right away. Now, just on that topic, I'll mention that a similar election as to jurisdiction is available for defence and more particularly prosecution in the Drugs Misuse Act. For the most part, when it comes to drug matters, where the matter is not something that must go to the higher court, which can be either the district court or the Supreme Court, or must be dealt with in the magistrate's court summarily, where there is a choice, that choice is with the prosecutor, essentially. So be aware that we don't have, as in defence, much room to manoeuvre in terms of saying where the matter is dealt with when it comes to a drug matter. I'm going to just refer you very specifically to Section 129 of the Drugs Misuse Act. That Act provides for what we call evidentiary provisions. And here's the one that I think is the most important, most interesting perhaps. That is, essentially, in summary, an occupier of a premises is deemed to have knowledge of a drug, and it is up to the occupier to show that they did not have knowledge nor reason to suspect the existence of drugs in or about the place. Now, that's very important when you're giving advice to an occupier of premises. The section itself reads, In respect of a charge against a person of having committed an offence as defined in Part 2, this is the Drugs Misuse Act, proof that a dangerous drug was at the material time in or on the place to which a person was the occupier or concerned in management or control is conclusive evidence that the drug was then in the person's possession unless the person shows that he or she neither knew nor had reason to suspect that the drug was in or on that place. So essentially, if you're an occupier of that premises, you accept responsibility for any drugs that might be in that premises. It goes on to say, and the reason I mentioned Section 24 of the Code as a defence is that it's relevant to this section, 129 of the Drugs Misuse Act, because 129 of the Drugs Misuse Act says the operation of the Criminal Code Section 24 is excluded unless the person shows an honest and reasonable belief in the existence of any state of things material to the charge. So you can see there's an interplay there as well. Now, for the purposes of this course, I don't want you to be bogged down in too much detail there by any means, but I'm really just keen to draw your attention to some of the more important aspects as I see it, and that's the only reason that I'm referring you to those defences and Section 129 of the Drugs Misuse Act. All right, any questions at this stage? Let me finish my discussion of criminal law with some comments in relation to bail, the practical procedures, aspects of sentencing, the concept of antecedents, and special rules that apply to the Children's Court. So if you can bear with me, I'll work my way through those, just making a few important comments, and particularly from the perspective of someone that's coming into the law. Bail. Your first week, you get a call from the watch house. Someone, a client of the firm, has been apprehended, is in custody, is about to appear before a magistrate, and would like you to apply for bail. The person who normally handles the matter is not available, so it's up to you to appear. What do you do? Time permitting, you make contact with prosecution, go through the aspects that we discussed before of asking for the court brief, the QP9, and in addition to that, ask whether there is an objection to bail, and if there is an objection to bail, ask if you could please have a copy of that objection to bail. The objection to bail is a formal document which is prepared by prosecution and presented to a magistrate typically. A copy should be provided to you, and it outlines essentially why prosecution are arguing that bail should be denied. Now, bail, of course, is something which is granted to a defendant which enables the defendant to be in the community and not kept in custody pending the outcome and finalisation of a matter. So when we talk about bail, it's really something which is provided either by the watch house or the court to enable that person to be released. When you're arguing bail, the important things that the court wants to know are these. Is the person able to attend at court? Where will the person be living? Is the person working? Does the person have any ties to the community, such as children or family? And essentially, are they a risk to themselves or to others? Are they likely to interfere with witnesses or not? Are they likely to re-offend? They're the sorts of things the magistrate may be considering when determining the question of bail. So when you go to the watch house and you take your instructions, you've got to keep those sorts of things in mind, because the magistrate may ask you specific questions about employment, residential requirements, ties to the area, etc. When you're looking at the criminal history, have a look for any instances of where the client has previously breached bail. That is a charge, breaching the bail obligations. And if you see that the client has three times, for example, been convicted of breaching bail obligations in the past, then you need to be prepared to argue in front of the magistrate as to why your client should be given bail on this occasion, when clearly the client has failed in his or her obligations to the court previously. On the flip side, just a word of warning. If your client was given bail by the watch house, and when I say given bail by the watch house, I really mean that the client has signed an undertaking as to bail, an undertaking to turn up at court at a certain time. So if your client was given bail at the watch house and freed, then required to attend at court on the first occasion, be aware of this risk. The magistrate may take the view that the watch house keeper was generous in providing the defendant with bail in the first instance, and may want to hear arguments from you as defence and prosecutor as to why that bail should be continued. In other words, just because the watch house keeper gives the defendant bail doesn't mean that the magistrate will agree and will allow that bail situation to continue. The magistrate may say, I'm not giving you bail, you're going into custody now. So the client needs to be aware of that potential risk. And be aware, of course, so that the question of bail is really a matter for the magistrate and the judge, is what I'm trying to say. Any questions about bail?
Yeah, just 2 points, John. Who is this watch house keeper? What qualifications do they have? Are they the police prosecutor or what?
No, thank you. I'm glad you raised that. Thank you. When you go into court and you're arguing in the magistrate's court in front of the magistrate, typically the police prosecutor will be a uniformed officer. Certainly that's the case in the regional centres. It may be a civilian prosecutor, or it may be a barrister or officer from the Director of Public Prosecution's office, but generally speaking the prosecutor is a uniformed police officer, usually sergeant or senior constable. The watch house keeper is also a police officer, but a police officer who has responsibility for the watch house. The watch house, of course, is essentially a place of incarceration, but it's not a jail as such. It's where it's an interim place, so that people who are apprehended, perhaps off the street or as a result of a warrant, are taken back to the station. They would typically go to the watch house. They may be interviewed, or they may choose not to participate in an interview. But if the watch house keeper decides to give them bail, they will then have an undertaking signed. The watch house keeper is typically a sergeant of police, quite senior, and will decide the question of bail or no bail from the watch house, generally in consultation with the arresting officer, the officer in charge, and or officers from prosecution. So does that answer your question, John?
Yes.
All
yes,
right.
thank you. Yes.
Thank you. Did you have 2 questions?
Oh yes, the second one. Well, this has actually been turned a little bit upside down because of the new anti-bikie legislation, where
Yes.
bail is not given automatically, isn't it?
That's right. It's always been the case that Section 16 of the Bail Act, which is an important one to have a look at, provides that the general presumption that someone should be given bail is reversed in certain circumstances. The anti-bikie legislation takes that much further in terms of the presumptions. Yes, I'd agree with that. Thank you, John. Any other questions or comments in relation to bail? All right. Now, procedure. At the first mention of a matter, you should, at that stage, know what the charge is. You should hopefully have a copy of the court brief and the criminal history. You should hopefully have spoken to the client and discussed the question of bail, discussed with the client the question of jurisdiction so that the client is aware as to which court will deal with this matter. You should have taken instructions from the client as to whether they wish to plead guilty to the charge or not guilty, or they haven't made up their mind, and approach the court, the magistrate, accordingly based on all of those factors. So let's take the example that I've been using most of tonight, assault occasioning bodily harm. Your client appears with you on the first occasion in front of a magistrate. You announce your appearance. We went through that in a previous situation, but just by way of reminder, I would say, for example, in relation to the matter of blogs, my name is Milburn, initials JA, solicitor, Milburn's Law, here on behalf of the defendant. Take the charge of assault occasioning bodily harm as read. Now, having said those preliminary comments, what the magistrate wants to know is this. Assault occasioning bodily harm is a charge which is subject to Section 552B of the Criminal Code. In other words, it's a matter that can be dealt with at the defence election, either summarily in the magistrate's court or by way of indictment in the district court. The magistrate is looking to you for advice as to the jurisdictional election. It may be that you choose not to make that election on the first mention and simply ask for an adjournment for, say, 2 or 3 weeks. But it is open to you on that occasion, having said to the court, we take the charge as read, to then say, I have instructions from my client that he or she wishes to proceed by way of indictment, meaning ultimately this matter is intended to be dealt with in the district court. So that's your choice. The magistrate's interested in that. Conversely, your election might be to deal with the matter summarily, and the client may have instructed you to dispose of the matter on the first occasion if possible, subject to the court's time and commitment. So you may say, I have instructions to take the charge of assault occasioning bodily harm as read. I have instructions to elect to proceed summarily. I have instructions to the effect that my client would like to take, does wish to take a certain course, and subject to the commitment of the court to do so immediately. Now, what that meant is this. We've basically told the court that we want to deal with it in this court, that it is a plea of guilty, and we'd like to deal with it today if the court's willing to do so, now, if possible. So you might be lucky. The court may say, yes, I'm willing to accept the plea now. When I said to the court that I have instructions to the effect that my client intends to take a certain course, what that means is that my client, if my client is charged now, or sorry, if the charge is read to my client now, formally, my client will enter a plea of guilty. Some magistrates will allow you to enter the plea of guilty or not guilty on behalf of the client. Some prefer not to do that. They want it from the client themselves. My personal preference is to always have the client enter the plea of guilty or not guilty themselves, rather than for me to do it. So I will generally speak in code to the court in terms of what I expect my client will say when offered the opportunity to say guilty or not guilty. There's 2 reasons I do that. The first is that I think it's good practice to say if something goes wrong and the client regrets the decision, ultimately it was the client who said guilty or not guilty, as the case may be. I didn't say it for the client made the choice, the client told the court. So that's one aspect. And the second aspect is this. As I recall, it was a decision of His Honour Judge Devereux of the District Court fairly recently, to the effect that it is proper procedure for the accused person to enter the plea rather than the solicitor to do so on his or her behalf. So for those 2 reasons, my preference is always to have my client enter the plea rather than to do so on behalf of the client. All right, so coming back to the procedure, assault occasioning bodily harm, we've got to the stage where we've told the court what we want to do. If the matter is proceeding by way of indictment, or if it's going to be contested in the Magistrates Court summarily, generally speaking, you'd be seeking a full brief of evidence, and even though there are prescribed rules that apply as per Moynihan directions in Brisbane, in the regional centres, by and large, we tend to stick to the old practice, which is to ask for either a committal mention date, in the case of proceeding by way of indictment, or a hearing mention date in the case of proceeding summarily. Both have the effect of an adjournment for about 6 to 8 weeks to enable the police to prepare the full brief of evidence. All right, now just backtrack to make sure you follow what I'm saying. So if I was to say, for example, take the charge of bodily harm, assault occasioning bodily harm as read, I have instructions that my client wishes to proceed by way of indictment, and I seek a date for committal mention, perhaps, let's say, the 10th of July. What I've basically said to the court is the matter's going to be going to the district court, and we'd like a full brief of evidence, and I'm nominating a date which fits within the court's guidelines, which is perhaps a date some 6 to 8 weeks away. All right, so there's a lot of code that we talk about. Magistrates and defence lawyers talk in code a lot, and part of what I'm trying to do is just allow you an opportunity to understand some of those terms. Now, any questions relating to those things? All right, thank you. Might be basic, but if we have a hearing of the matter in the Magistrates Court, there's no jury, so we call that generally a summary hearing. If the matter goes to a hearing in the District Court in front of a trial, that would normally be referred to as a jury trial. So we tend to say hearings in the Magistrates Court and trials in the District or Supreme Court. And I think I mentioned in the past that the process or the filter of getting a matter from the Magistrates Court through to the District or Supreme Court is the process of committal. The most common, particularly these days, is what we call a hand-up committal or a registry committal. That is a committal where there's no cross-examination of witnesses. All right. Now, in the short time we have left, sentencing. When a matter is adjourned for sentence, what that means is that on that next court date, the client will either enter the plea of guilty and receive punishment, or, having entered the plea of guilty, will receive the punishment on that next occasion. And when I talk in terms of the punishment, what I'm really saying is the court will impose its penalty upon the accused. Sentencing options. It might be, in the case of adults court, that the person is discharged without any penalty. They might be placed on a good behaviour bond, or reconnaissance as we call it, which is really a statement to say that during a period of time they will be good, stay out of trouble, and if they're not, they may have to forfeit some money at that stage in accordance with the bond, perhaps even be resentenced with the original offence. Next up we have fines, monetary fines. Most of those these days are referred to the State Penalty Enforcement Registry, and that's generally done directly by order of the court. Above fines we have probation, community service, or perhaps even both. Above that we get into the jail sentencing options, and jail or detention has a number of different options within it. The most severe, of course, is jail. You go to jail and you serve your time. Generally in Queensland you serve about a third of the time and then you're released on parole. Or it may be, coming down the scale, that you're released on parole after a short period of time, or maybe even released immediately, but subject to parole immediately. It may be that someone is given a detention order but requested to serve that by way of an intensive correction order, which is really serving a term of imprisonment but in the community. Or it may be that a term of imprisonment is wholly suspended, meaning immediately, or suspended after a period of time, after serving a period of time. So the point about sentencing is that there are a whole range of those options available, and I'd urge you to read the Penalties and Sentences Act, which provides an outline of those sentencing options and principles. Antecedents. Now, the reason I'm mentioning this word, A-N-T-E-C-E-D-E-N-T-S, antecedents, is that if you get into a law firm or you're working in the criminal law, you may be confronted with a request from a partner on the first day to this effect: look, I'm too busy to see this client. Can you just speak to them, get and obtain their antecedents? If you don't know what antecedents means, you'll be wondering what the partner's talking about. Antecedents is really find out or obtain instructions from the client as to that person's background, their circumstances, relevant factors that may have an influence on the court in terms of a sentence which might be imposed. For example, if the client has a mental health history or has various problems associated with learning or disability, you need to obtain those. You need to obtain that information. Conversely, clients may have hopes and aspirations, may have employment opportunities. It's important that all of that is gleaned and taken from the client, because it may have a bearing on penalty. For example, if someone was studying law online with aspirations to being a lawyer, but was found before a court on sentencing, you would want the court to know about that study, because it may be relevant to the decision as to whether a conviction should be recorded or not as part of the ultimate sentence imposed upon that person. So when we talk about antecedents, we're really talking about getting a snapshot of relevant information from the client, useful, particularly in the sentencing process. Have I confused anyone there? Okay. Next one, perhaps the final one for tonight, unless there's any questions afterwards, is Children's Court. As we've identified, the Children's Court is the place where matters involving people under the age of 17 primarily are disposed of. It's subject to a totally different sentencing regime, and in many ways different practices apply. I'd refer you to the Youth Justice Act 1992, and that's an important piece of legislation. It is essentially a code when it comes to dealing with juvenile justice issues, subject to some of the defences, for example, that I've referred to in Chapter 5 of the code still apply, but in terms of the overall sentencing regime, it's a special regime in the Children's Court. From a practical point of view, there are some other differences as well, and I'll just highlight two. If you find yourself representing a child in a criminal law proceedings, having previously represented someone in the adult court, the two things that you'll notice immediately are, firstly, that the Children's Court is what we call a closed court, so it's not open to the public. So you'll go in with your client and a parent or parents and or guardian, but extended members of the family should be told to stay outside where members of the public will remain. That's the first point. The second point is that when you get into court, essentially most magistrates take the view that the only person who should be standing is the accused child. Everyone else remains seated. And that's the case for most magistrates, but I like to make inquiry of the magistrate from the outset as to his or her preferred practice in that regard, so that I then comply with those requirements. It's a little different when we get to the District or Supreme Court. The normal rules apply, But when you're in the children's court, which is essentially at the magistrate's court level, just be aware of those two important differences between it and the adult jurisdiction. Perhaps the third point of difference is that in the children's court, there will be a representative of the department, youth justice or juvenile justice, and that person will provide the court with information relevant to the case as well. All right. I'm hoping that you've reached a stage where you've at least got some of these basic terms in relation to criminal law, that you'd be comfortable that if you're confronted with that awkward situation in your first week of being able to at least understand some of the basic principles in terms of procedures and sentencing and some of the options that are available to you. These comments aren't meant to be a replacement to the criminal law course, of course, the criminal law degree subject, of course, but are designed to just get you through that first bit of your practice. All right, any questions then about criminal law? Thank you. What I propose to do next week is have a brief discussion in relation to contract law and talk about formation of a contract, offer acceptance, communication, and some other aspects of contract law, and then move into some other areas of legal practice, all with a practical bent, if you know what I mean. All right. Well, at this stage, unless there are any questions, I'll simply stop the recording. Thank you.